So I have had pretty good exposure to what's happening in Africa, and particularly our sub-Saharan continent. And SARS is certainly an extremely aggressive force and has been for a considerable period of time, but it has now been handicapped by unfortunate issues that are now coming out in this Commission of Inquiry. And so as much as it is a very aggressive entity with excessive powers, and you would have seen from the midterm budget speech of Tito Mboweni yesterday that things are not looking good there. And so I think you as accountants and your clients no doubt are seeing the effects of that in terms of an uptake in verification audits and revised assessments and collection attempts where they've even now introduced third-party agencies that are telephoning taxpayers as far back as issues that arose 15 years ago. So, things are not looking good. And that means that we as taxpayers and the advisors are going to face a tremendous onslaught that's going to pick up. And I want to just share with you some of the things that I'm working on just to give you an idea of what is happening. My clients all face these tremendous powers that SARS has and that these revenue officers have. And they basically can jump to conclusions based on non or inconclusive evidence, and you're put on the back foot where you have to discharge the burden of proof and have to collate all the documentation and the evidence and everything else that goes with it, effectively to prove your innocence in the charges that they're going to make against you. And when they raise those assessments, the pay now, argue later principle immediately comes into effect. And so when those assessments are raised and you have all of these fingers pointing at you, you kind of feel a little bit helpless, and especially in the current circumstances where SARS is having to be not only a lot more aggressive, but the incompetence is of such a nature that we no longer see the depth of knowledge and expertise that existed under Pravin Gordhan many years ago, where you could reason with them and they would actually see that their interpretation of a particular provision is patently wrong. Now they nitpick at everything that they can find in order to justify what they're doing, to prove to their seniors that there is a large claim to be had. And so we're finding it extremely difficult to deal with them. But in all of that, and in all of those matters, the thing that stood out for me is even if the clients were wrong, those clients had fundamental rights that they were entitled to invoke in their dealings with SARS. And so as much as SARS have these heinous powers, the taxpayers have the right to match those powers with fundamental rights that they have. And so many of those cases were won, not just on the technical merits, on the facts and the incorrect interpretation of the laws by the SARS officials or the revenue officials concerned. We were able to show them up in not following proper procedures in the execution of those duties. And so when you have such heinous powers, you have to follow the steps that the law has set out, and that's underpinned by the Constitution. And so the ability for chartered accountants and specialist lawyers to work together in this particular field is fantastic. And I will not go into a matter without the participation of the chartered accountant of the client concerned, because they normally are very knowledgeable as to the facts, and we win matters ultimately not just on the procedural glitches, but we win them on the facts as we apply those to the principles of law. And so therein lies an opportunity for a fantastic relationship to be built. Now that all sounds fantastic if you're a multinational and you've got deep pockets, because to get those two people to sit together with their teams, you can imagine what that hourly rate's going to be. It's exorbitant. And so the creation of this policy, I was very much involved in one of the entities that merged to form TRU, And my dream was to be able to create a vehicle whereby smaller customers or clients or taxpayers would be able to access that expertise and have the opportunity for those two teams to work together to ratchet down any challenge from SARS, and hence the creation of the policy, so that the policy covers those tremendous expenses that will be incurred for you to be able to buy the best. And you want to buy the best. So if we talk about risk management, what is the likelihood that you are going to face an audit? We don't really know. But if you look at the statistics and you look at the percentages put on the board in front of you and you do a quick analysis, there's a 50-50 chance in the next 10 years that you're going to face some kind of tax audit. And I'll give you a classic example. So something that's doing the rounds at the moment, a typical financial statement will show that the company has advanced funds to third parties. So what does SARS do? They see that, they immediately trigger a verification audit, and they say this is a 24 capital F transaction. In other words, they are now deeming the loans from the company to those individuals or entities as being loans where there normally would be interest-free. They compute what the market-related interest charge should have been and then calculate a dividends tax and charge you with dividends tax. They don't even interrogate whether or not those third parties are connected persons in any way to the company. And so now you have to go through the process of answering to that. So, you know, and even if you tell them that they're not connected persons, they don't care. They just issue the assessments anyway. And Skalk will explain to you in that particular process, by simply issuing those assessments, they are failing to comply with a very important part of the Tax Administration Act, which is issuing a letter of findings. And so on the face of it, you can have those assessments set aside. And we were successful in doing that in a Port Elizabeth tax case last year where the judgment was handed down in February. When you raise that letter of objection, do you think SARS is going to respond timeously? And they won't. And how many of you have got outstanding letters of objection that are way past the 60-day period? And despite making telephone calls and addressing correspondence to SARS, do they bother answering you on it? Most likely not. So what are your rights? What do you do in that particular case? Now, I've already told you, you may not even have to go there if you're able to challenge them on a failure to issue a letter of findings. So many of you may know that we are party to the AGOA agreement with the United States. And so roundabout what the AGOA agreement does is it allows us to export all these fancy motor cars that we manufacture in South Africa for the American market without having to pay any import duties in the United States. So it's a big driver for the economy here. America turned around in 2015 and said, listen, we don't think that your country really fits the mold of who should be in the AGOA agreement. We're really trying to help poor African nations. And so, of course, the DTI and ITAC then scrambled to the negotiation table, and it was negotiated that because what South Africa had done is they had blocked certain imports from America by virtue of imposing anti-dumping duties. And one of those products was bone-in chicken, and we all like eating chicken. And so the negotiations ended up in an agreement that America would be able to dump about 800 tons of chicken, bone-in chicken, from their large producers all over the United States into the South African market without any anti-dumping duties being imposed. And that would keep the AGOA agreement with South Africa alive, where our trade back into America far exceeds the bone-in chicken meat coming here. So agreements were reached between the Department of Agriculture, Forestry and Fisheries, ITAC, DTI, and those entities issue permits, and it was decided that 50% of those permits would be issued to historical importers of chicken, and the other 50% would be issued to previously disadvantaged persons who know absolutely nothing about import, certainly not in the chicken industry, and certainly don't have the ability to finance anything. So I don't know if any of you are involved in import trade, but that chicken is not going to be placed into a refrigerated container unless it's paid for or there's a letter of credit. Now, if you're a startup business, do you think any bank is going to provide you with a letter of credit to pay for that transaction? Absolutely not. Do you think that those people know how to fill in all the documentation despite having the assistance of clearing agents to bring that product across and then sell it ultimately to a Pick and Pay or to a Woolworths or to a Spar where their payment terms are what? 120 days? So do you think those guys are going to get any finance? No. So it was understood that the historical importers would help these previous disadvantaged parties, and the relationship has worked well for 3 years. SARS gets this bright spark idea at the beginning of this year and decides, no. This is fronting. And we as SARS, who have nothing to do with issuing the permit, are now going to deem these permits invalid, and we are now going to deem all these historical importers as the actual importers, write back all the anti-dumping rebates, and charge these historical importers not only with the duties that by rights should not be charged, with heinous penalties, and while we're about it, we'll just throw in holding everybody that was individually involved in the transactions personally liable as well. I mean, that's pretty harsh. Now, we've taken the matter to 2 senior counsel who appear for SARS frequently. And both of them have said, what an absolute lot of nonsense. It's just nonsense. But that's what they're doing. Another example, also customs and excise, on the exportation of diesel up into Africa. So their argument is there are these depots that have fuel going into them, and as long as the fuel gets exported, then you get a rebate on the fuel excise duties payable on fuel. And so in that particular instance, they're actually wanting the company to identify. Now you must understand there's a pipeline coming in, and there are various entities like Total, BP, and others putting the same fuel into this pipeline. And so you can measure the volumes going in, and you can measure the volumes going out. You can never identify which is Total's fuel or which is BP's fuel, because guess what? Fuel commingles like water. It doesn't have like a registration number attached to the molecule. And they literally want us to be able to identify which fuel is ours for export. I mean, and again, same senior counsel consulted, absolute nonsense. But guess what? Over a billion rands worth of refunds being held back because of this type of nitpicking. Now you can imagine what the fees are costing. The one senior counsel settled our letter that we wrote. So when settled means we wrote a 12-page letter with a whole bunch of annexures and attachments, very nicely done. He took the letter, read it, which is his job, looked at the papers, which is his job, recreated paragraphing. He used square brackets as opposed to just numbering, made a few adjustments. Any guesses on what his bill came to? Any guess? You have 3 guesses. Come on, somebody, just throw a number. How much? 50. 50 rand. 50 grand. Next? How much? We're getting close. We're getting close. With a discount. Just under 200,000. That was just the silk. And it's nonsense. And so, the stories go on. So we have a case that we won in PE. This very case in February was for a CEO of a listed company who had spent over 1.8 million on farming expenses and received a 7.1 million severance package. And so the fight was about the 1.8 million tax deductions and whether a CEO of a listed company could be retrenched. There isn't such, how do you argue such a thing? Trust me, it's arguable, but that's a different discussion. How do you retrench a CEO? So SARS wanted to tax that 7.1 million at a much higher rate, not at the average lump sum rate that would normally apply in a retrenchment situation, because their argument was, you can't retrench a CEO. Trust me, you can, but that's not the point. That was the case where we didn't even get to argue the merits because SARS failed to issue a letter of findings. So the court came to the decision, throw the whole assessment out, orders the assessment to be reversed. So guess what? When was that judgment? February. We're now in October. We are still waiting for SARS to execute that judgment. So the debt still stands. We have written, we have pleaded, we have scraped, begged, we have even sent an email to the acting commissioner himself. Nothing. So guess what now? We're bringing a contempt of court application. Do you know what that means? That means if we can prove the commissioner personally knows about this order and has failed to execute it, he will be imprisoned for contempt of court. Why is this necessary? The client has to pay for the application. Now, hopefully, like the other application, we'll get a costs order against SARS. And Skalk told me that the bill of costs runs into the hundreds of thousands, which SARS, if we're successful, which SARS will have to pay. But that's not always the case, because often when you bring these applications, SARS settles. So there's a gentleman in the audience who will remain nameless unless he wants to put his hand up, who I represented one of the companies that he was director of on SARS literally reversing all VAT input tax credits from inception. It was just ludicrous. So we try and correspond with these people. It's like knocking on a hard wall. So we bring an application. The moment we brought the application, they backed off. So now, do we push the application, go to court, get a costs order, or we just accept that they're going to reverse everything again and move on? After they incurred, if I remember correctly, in excess of 400,000 rands in fees. Why must the taxpayer sit with that bill? But that's the type of thing that's happening. And the problem is that when we go back to the rights that you have as taxpayers, the problem is use them or lose them. If you don't use them, then the machine carries on clicking forward. You have to challenge them on these mistakes, and they make plenty of mistakes. Not just in terms of the technical issues that are going to be argued in a tax court. They make lots of procedural mistakes. And you need to get the best possible advice on your side with you, the accountant, who has the relationship with the client and who is able to provide proper facts in order to advance these cases.